Welcome. We are going to be discussing the Code of Canon Law of 1983, which is a code of the Latin Church promulgated on the 25th of January 1983. Its official presentation occurred on the 3rd of February of the same year, and it entered into force on the 27th of November 1983. It contains the Apostolic Constitution, Sacrae Disciplinae Leges, the historical and legal preface, and the 7 books of which it is composed. These are the 7 books: the General Norms, the People of God, the Teaching Office of the Church, the Sanctifying Office in the Church, the Temporal Goods of the Church, Sanctions in the Church, Trials and other processes. Remember that there was also the 1917 Code of Canon Law, which was organized according to the Romanistic categories of persons, things, and actions, namely the organization of people and institutions, a structured set of things necessary to ensure continuation of the ecclesiastical order: sacraments, sacred places and times, divine worship, ecclesiastical magisterium, privileges, temporal goods. So it was divided into 5 books: General Norms, Persons, Things, Trials, Crimes, and Penalties. We are talking about the Latin Church. There is also a code of canon law which belongs to the Eastern churches. And this code, we are not going to be discussing about it. We will limit ourselves to the 1983 Code of Canon Law, which is for the Latin Church. Let us go to the general norms. We have the introductory canons, that is Canon 1 to Canon 6. The first 6 canons can be defined as provisions for the application of the code itself, with respect to its scope, to other laws that could be related to it, to acquired rights and privileges of the persons, and finally, to the previous legislation. Canon 1 regulates the field of application of the legislation and determines which subjects are bound to it, so that the canons of the 1983 Code of Canon Law concern only the Latin Church, while those of the Eastern Catholics are obliged by the canons of the Eastern churches. The second canon of the Latin Code regulates the relationship between the code and the liturgical law. Most laws regulating the liturgy are not present in the code. Therefore, the liturgical laws so far in force shall remain in force. If the canons of the code modify, derogate, or abrogate a liturgical norm, the latter must immediately be amended, derogated, or abrogated, as the case may be. The code prevails over the liturgical laws due to its universal value. The third canon of the 1983 Code regulates the relationship between legal systems. However, while the second canon of the 1983 Code regulated within the church, here they determined the relationship with other juridical systems at an international level. The canons of the 1983 Code do not alter in any way all the concordats and agreements, despite the fact that they may contain abrogative or derogatory provisions. They continue to have their value, despite the promulgation and coming into effect of the 1983 Code of Canon Law. If any canon was contrary to the provisions of an international agreement, that provision and the agreement would continue to remain in place, even if contrary to the code. All that was decided unanimously by two parties in a contract cannot be revoked or amended, even partially, by one of them, except, of course, the divine law. Therefore, the ecclesiastical legislator cannot modify on its own authority the agreements. This entails also the concordats, treaties, modus vivendi, protocols, and agreements of various kinds signed or approved by the Apostolic See with nations or with other civil entities. And there is the obligation to observe the fundamental rule, which is pacta sunt servanda in Latin. The relationship governed by the fourth canon of the Latin Code does not concern the two legal systems, but first, the objective normative rights, the law, and the subjective rights of physical and juridical persons lawfully acquired. Secondly, canon law and the subjective rights of the same persons lawfully granted by the competent authority. Acquired rights remain intact, although the law under which they were actually acquired has changed. When in the canons of the code there is an explicit or implicit contrary provision to the rights already acquired because of the common good, then the acquired right is immediately revoked. What about privileges? Privileges remain undisturbed as well, since these are favors either contrary to the law or outside of the law, which are not part of the legal heritage of the person, but are exemptions to the law granted by the legislator. The legislator is free to reduce, revoke. Therefore, there are conditions to grant these privileges. They should be granted by the Apostolic See. One should consider if such privileges were still in use when the code was promulgated or not, or if there has not been a previous or current revocation through a formal act by the competent authority. The exception of the permanence of privileges is realized under the same conditions as for acquired rights. The code also regulates the relationship between customary law and canon law, which concerns the same canonical legislation. As a custom in the church has the force of law, even though the code regulates its formation and also its existence. These are very important provisions for the ecclesiastical discipline concerning the relationship between the customary system in force prior to the promulgation of the code and the current canon law system already promulgated and entered into force. Customary law constitutes a major source of ecclesiastical law, especially in the life of the early church, where many customs and proven practices of the early centuries have had a significant impact and have subsequently become canonical norms. Canon 5 of the 1983 Code govern primarily the relationship between the code and the customs, contrary to the law, distinguishing between reprobated and non-reprobated custom. Then they govern the relationship between the code and customs outside the law. And finally, the relationship between the code and customs under the law. Since by their nature, customs according to the law are the concrete way in which the people of God puts into practice the canon law, the canonical laws, they follow the fate of the corresponding law. In all cases, customs are a good principle of interpretation when they refer to the previous legislation retained in the current code. They are an essential point of reference to the traditio canonica, since custom is the best way to interpret the laws. That we have to keep in mind. Now, let us go to the ecclesiastical laws and customs, and this is a discussion which we are going to take in the second episode of this particular channel. Thank you very much.